Are you serious? Are you serious? Guys, it's time to read the memo. It's time to read the FISA memo. I'm going to read it. I'm going to show it to you. And we're going to read it together. It is time. It is time to read the memo. Let me pull up right here. The memo. Give me 1 second. I got to grab this camera. Might have been a better way, but there might not have been. Anyway, I'm sorry about that. Here's the memo, and we're going to read it. The White House wrote the letter authorizing the memo to be read. Okay, so the counsel of the White House, and that's what this letter is, letting the chairman know that the Honorable Devin Nunes, chairman of the House Permanent Select Committee on Intelligence of the United States Capitol, has been authorized by the President of the United States to go ahead and release the memo. It has been declassified by the President of the United States, okay? And so now let's just, instead of going through the legalese of that, let's just get into the memo as it has been declassified. Everybody signed off on it, and it was sent to the Honorable Paul Ryan, Speaker of the House, and the Honorable Adam Schiff, of the ranking member of the House Permanent Select Committee on Intelligence. It is now unclassified. Give me a second here. I'm going to try to do a better job with this camera, if I can. The purpose, this memorandum provides members an update on a significant facts related to the committee's ongoing investigation into the Department of Justice, the DOJ, Federal Bureau of Investigations, and their use of the Foreign Intelligence Surveillance Act, or FISA, during the 2016 presidential election cycle. And let me get this off here for you. I'm so sorry. During the election cycle, our findings, which are detailed below, raise concerns with legitimacy and the legality of certain DOJ, Department of Justice, and FBI interactions with the Foreign Intelligence Surveillance Court. And two, they represent a troubling breakdown of the legal process established to protect American people from abuses related to the FISA process. Investigation update. On October the 21st, 2016, the Department of Justice and the FBI sought and received a FISA probable cause order, not under Title VII, authorizing the electronic surveillance on Carter Page from the FISA, from the FISC. Page is a U.S. citizen who served as a volunteer advisor to Trump's presidential campaign. Consistent with requirements under FISA, the application had to be first certified by the Deputy Director of the FBI. It then required the approval of an Attorney General, Deputy Attorney General, known as the Deputy Attorney General, or DAG, or the Senate-confirmed Assistant Attorney General for National Security Division. The FBI and the DOJ obtained one initial FISA warrant targeting Carter Page and 3 FISA renewals from the FISC. As required by statute, a FISA order on an American citizen must be renewed by the FISC every 90 days, and each renewal requires a separate filing of probable cause. Then Director James Comey signed 3 of these FISA applications in question on behalf of the FBI, and Deputy Director Andrew McCabe signed 1. The DAG, Sally Yates, then acting Deputy Attorney General, and Dana Botnay and Deputy Attorney General Ron Rowenstein each signed 1 or more FISA applications on behalf of the DOJ. And due to the sensitive nature of foreign intelligence activity, FISA submissions include renewals before the FISC are classified. As such, the public's confidence in the integrity of the FISA process depends on the court's ability to hold the government to the highest standard, particularly as it relates to surveillance of American citizens. However, the FISC's rigor in protecting the rights of Americans, which is reinforced by this 90-day renewal of surveillance orders, is necessarily dependent on the government's production to the court of all material and relevant facts. This should include information potentially favorable to the target of the FISA. Property of the United States House of Representatives. This was top secret. You can see it's been crossed out. It was top secret. Application that's known by the government. In the case of Carter Page, the government had at least 4 independent opportunities before the before the FISC to accurately provide accounting of the relevant facts. However, our findings indicate that, as described below, material relevant information was omitted. Number 1, the dossier, compiled by Christopher Steele, or the Steele dossier, on behalf of the Democratic National Committee, or the DNC, and Hillary Clinton campaign. They formed an essential part of the Carter Page FISA application. Steele was a longtime FBI source who was paid $160,000 by the Democratic National Committee and the Clinton campaign via the law firm Perkins & Co. and research firm Fusion GPS to obtain derogatory information on Donald Trump's ties to Russia. Neither the initial application or in the October 2016, nor any of the renewals was it disclosed or referenced the role of the DNC, the Clinton campaign, or any party campaign in funding Steele's efforts, even though the political origins of Steele's dossier were then known to the senior Department of Justice and FBI officials. The initial FISA application notes that Steele was working for a named U.S. person, but it does not tell you or does not name Fusion GPS and its principal, Glenn Simpson, who was paid by a U.S. law firm, Perkins & Co., representing the Democratic National Committee, even though it was known by the Department of Justice at the time that political actors were involved with the Steele dossier. The application does not mention Steele was ultimately working on behalf of and paid by the Democratic National Committee and the Clinton campaign, or that the FBI had separately authorized payment to Steele for the same information. The Carter Page FISA application also cited extensively a September 23rd, remember that? A September 23rd, 2016, Yahoo News article by Michael Iskoff, who focuses on Page's July 2016 trip to Moscow. This article does not corroborate that Steele dossier because it is derived from information leaked by Christopher Steele himself to Yahoo News. The Page FISA application incorrectly assesses that Steele did not directly provide information to Yahoo News. Steele has admitted in British court findings that he met with Yahoo News and several other outlets in September of 2016 at the direction of Fusion GPS. Perkins Cole was aware of Steele's initial media contacts because they hosted at least one meeting in Washington, D.C. in 2016 with Steele and Fusion GPS, where this matter was discussed. Steele was suspended and then terminated as an FBI source for what the FBI defines as the most serious violations, an unauthorized disclosure to the media of his relationship with the FBI in the October 30th, 2016 Mother Jones article by David Korn. Steele should have been terminated for his previous disclosed contacts with Yahoo and other outlets in September before the Page application was submitted to, and then of course, again, unclassified now, property of the U.S. House of Representatives. It was top secret. For top secret, it's been crossed out. The FISC in October, but Steele improperly concealed from and lied to the FBI about those contacts. Remember, James Comey also leaked vital information of this to the media by his own admission under oath. Steele's numerous encounters with the media violated the cardinal rule of source handling, maintaining confidentiality, and demonstrated that Steele had become less than reliable source for the FBI. Before and after Steele was terminated as a source, he maintained contact with the Department of Justice via then Associate Deputy Attorney General Bruce Orr, a senior Department of Justice official who worked closely with Deputy Attorney General Sally Yates and later Rod Rosenstein. Shortly after the election, the FBI began interviewing Orr, documenting his communications with Steele. For example, in September of 2016, Steele admitted to Orr his feelings against then-candidate Trump when Steele said he was desperate that Donald Trump not get elected and was passionate about him not being president. This clear evidence of Steele's bias was recorded by Orr at the time and subsequently in official FBI files, but was not reflected in any of the Page FISA applications. That's to get the warrants to spy on Carter Page and everybody else associated with Carter Page. That's how this works. So during this same time period, Orr's wife was employed by Fusion GPS, oh how convenient, to assist in the cultivation of opposition research on Trump. Orr later provided the FBI with all of his wife's opposition research, paid for by the Democratic National Committee and the Clinton campaign via Fusion GPS. The Orr's relationship with Steele and Fusion GPS was explicitly concealed from the FISC. Wow. And according to the head of the FBI's Counterintelligence Division, Assistant Director Bill Priestap, collaboration of the Steele dossier was in its infancy at the time of the initial Page FISA application. After Steele was terminated, a source validation report conducted by the independent unit within FBI assessed Steele's reportedly as only minimally collaborated. Yet in early January 2017, Director Comey Director Comey briefly briefed the President-elect Trump on a summary of the Steele dossier. even though it was, according to his June 2017 testimony, salacious and unverified, while the FISA application relied on the Steele's past record of credible reporting on other unrelated matters, it ignored or concealed his anti-Trump financial and ideological motivations. Furthermore, Deputy Director McCabe testified before the committee in December of 2017 that no surveillance warrant would have been sought from the FISC without the Steele dossier information. So in other words, without the pack of lies that they conjured up with the paid-for Steele dossier, there would have never been a warrant given. There would have never been a FISA warrant given to go hunt down Carter Page and everybody Carter Page talks to, and everybody they talk to, and everybody they talk to. They can go 3 generations. Unclassified. It is now unclassified. Here's the final paragraph. Property of the U.S. House of Representatives. It was top secret. It was. The Page FISA application also mentions information regarding fellow Trump campaign advisor George Papadopoulos, but there is no evidence of any cooperation or conspiracy between Page and Papadopoulos. Papadopoulos information triggered the opening of the FBI counterintelligence investigation in late July of 2016 by FBI agent Pete Strzok. Strzok was reassigned by the special counsel's office to the FBI Human Resources for improper text messages with his mistress, FBI attorney Lisa Page. Texts also reflected extensive discussions about the investigation and orchestrating leaks to the media, and including a meeting with Deputy Director McCabe to discuss an insurance policy against President Trump's election. Folks, this is the FISA report. It is unclassified. It is revealed by us. We're not going to put spin on it like all the media. It's pretty self-explanatory. And they don't even mention all the salaciousness of the texts between Strzok and his mistress, Lisa Page, and how that a secret society exists within the leadership of the FBI and the Department of Justice. And oh, by the way, you know what this memo does not have? It doesn't tell you who made the idea to go after everyone. Who called the first shot? No mention of President Barack Hussein Obama. Deep state, unclassified. I'll be back with more current world events. Folks, are you serious? I mean, seriously? 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 Are you serious? We will be back with more current world events. We're staying on top of it. The FISA memo, the deep state, the Illuminati, the Luciferians, the New World Order, the biblical beast. Discovered, uncovered, uncut.